I was wondering if I could speak about the best mode of delivery of LOAC training. Whether in Zambia you use primarily classroom instruction for LOAC training, or a combination of classroom instruction and training on exercise, for example.
Thank you. I think that it's really been a process of change and evolution in terms of our approach. But currently, as it stands, and the way it's been even in the last period, I think that the classroom instruction has still remained the most primary and basic way in which we do our training. Obviously, we have that's been affected by lots of different things. Of course, the expertise in LOAC, if you have a certain number, mostly the classroom instruction and has been the most primary one. But one thing I can mention that we have been trying to do of late, and I think has been working so well, is drills and rehearsals are very much a part of our training in Zambia. And then so when we do some of these drills and rehearsals and maybe a bit of simulation or exercises, or even planning, there is now at least always a component where we try to, where we always add IHL or LOAC, as you may call it, in that sense, as a mode of delivering the conversation on these things. But primarily, the classroom instruction has to remain the most basic, and we're trying to find ways of not making it more like dry conversation, but making it more interactive, and making sure, obviously, the people that are training are a little bit more engaging to allow people, obviously, to reflect more on what they're being taught. But it still remains the most basic, because obviously it's also administratively much more needed because of the costs involved in it. Much more easier than obviously simulations and other exercises. But maybe before I just finish on that, Elizabeth, I would like to mention also as well that we've also noticed that because of the technology that is coming in terms of, you can show on the screen a few exercises and a few simulations, and there's all these teaching aids that are coming from technology. Even if you're in the classroom scenario, that is something that we've been trying to adopt, and we have adopted, and I think that it looks very positive, especially when it comes to bringing the reality of the norms to the soldiers that are being taught.
Yes.
It's evolved over the years to just obviously giving them placards or short notes of what the norms are for them to read over and over again, to more of a discussion about what they think about the norms, about our obligations towards those norms, how they think that those norms reflect maybe either our values or the ethics that we have as military officers, and why those norms are actually very important. And this also has been a bit of a difficult thing, because that also means that in a training program that's a bit shorter, you probably now need to allocate more time for LOAC training, because obviously these trainings are not just focused on LOAC, they are focused on other aspects as well that appear obviously to be maybe more core. So yes, there has been an increase in the time that has to be spent to allow officers obviously to ask questions, to reflect on the molarity of it, and obviously to even watch live situations where those things have happened from a moral perspective, and more in a way to try and persuade them in a sense about the importance of those norms. So it's been work in progress, really, from almost a dry classroom instruction where you probably have to tick the box that they've been taught, to something a little bit more core. And that's the approach that we've been taking, especially for military officers. Perhaps maybe more that could be done and that's being worked on is that obviously that reflection becomes more as officers go into more of their higher echelon trainings at the rank of major or lieutenant colonel and thereabouts, and probably more needs to be done to a bit more of the junior officers.
Exactly. It's a reflective work in progress for those designing and implementing the training as much as it should be for those receiving the training.
Yeah.
I know from my own research, I'm incredibly skeptical about detailed, comprehensive, scripted and standardized training in international humanitarian law. I see its appeal in terms of designing a national rollout of IHL training for an entire armed force, and to ensure that every single box in a comprehensive approach is ticked. I see that appeal, but I also see its insufficiency. I've written recently on the British Army's comprehensive reforms to law of armed conflict training, following some quite serious violations against detainees in British military custody in the early phase of the deployment to Iraq in 2003. And the training, especially since 2014, has become incredibly comprehensive. And that tick box is impressive. But the questions remain on the extent to which that discursive element is present, the extent to which the shared values of restraint and the willingness to comply with those restraints is carried out in addition to all this detailed scripted training. And there's also the use of technology and the use of some training on exercise to supplement this detailed, comprehensive, and I would say also good faith reformed training in IHL. But the ICRC's recent research on the importance of shared values of restraint keeps all of us working on military training in LOAC, in effect, on our toes as we reflect upon the necessity but arguable insufficiency of merely disseminating the legal prohibitions.
In Zambia, for instance, this is something, I mean, being a former British colony, this is something we've carried on from the British, but I mean, there's a lot of teaching about spirit decor, you know, about the cohesion of a unit and the brotherhood and soldiers being together and the culture that you have. And you find that because of everything they go through together, the bonds between them are quite high. And then, for instance, if anything happens to any of the members of that group or that community, the reactions, trying to restrain the reactions to be within the norms of IHL and trying to drill that home has been obviously a challenge, even when you're asking or answering questions from them about simulations and what they are ordinarily supposed to do in a certain situation. So even if they know the norm that you have taught, there's still a certain degree of skepticism about whether they should adhere to it in certain circumstances. Yes, that's been a challenge, and it's actually been a challenge even at the highest level of training within our defense force.
I think that this, again, is generalizable across multiple states. And I think it's very true that attention to effective military training in IHL needs to consider the physical exhaustion and the moral distress of the battlefield, especially when there have been friendly casualties, and when that temptation for what I would call false reciprocity tends to slip in. The idea that if opposing armed forces or an opposing armed group is not complying with international humanitarian law, then can international humanitarian law really be so imperative? And it's that absolutely obligatory normativity of international humanitarian law, with all its room for tensions and discretion at points. It's that matters so much in terms of instilling that in troops at all levels, that it isn't optional, and that it does not compete with your shared values, with your loyalty to those in your unit, and it doesn't compete with larger political discourse. So, for example, in the UK, there's been a considerable political discourse that because international humanitarian law training has now been reformed, there is no need to address past allegations of war crimes, particularly against detainees in military custody. And that in effect, the training is all solving and does not require those investigations and where evidence suggests prosecution in court-martial. And this isn't how the whole gamut of international humanitarian law works. So yes, certainly, as much as recent research is focused on law and shared values, I think we also need to consider those conflicts between law and viscerally felt values on the battlefield.
So for us, it's got potential. We look at it as one of those things that is actually going to encourage or at least compel states to ensure that it's on their agenda all the times, because they know, look, at the end of the year or at the end of 2-3 years, we need to make this report. And this report can't be the same as the report last year. We need to make improvements. It's also an opportunity for us to reach out to partners and friends to see how they're doing, to see how we can improve things. So, of course, there are administrative issues and costs that are also associated with state reporting. But for me, I think it's a potential. It's a potential. Obviously, like I said, it's got its own pitfalls where, obviously, when people submit a report, there's an understanding maybe by some quarters that, well, they have fulfilled an obligation that they have, even when, maybe when substantively a few things might not have been done. But I think that state reporting has been around for a long time, and I think the international community has developed lots of mechanisms that can make this state reporting a bit more substantive, yes, and a bit more meaningful in improving our approach and in learning as we do that. So I see a lot of potential in that. I see a lot of potential in how state reporting, for instance, can always make sure that IHL is on the agenda when we're making any training program, when we're reforming our manuals, and when we're having any course at all. Even when we're having a few crash courses that we have for soldiers, maybe for a certain specific mission, we'll make sure that it's always on the agenda, even when there are other conflicting topics around. So I see a lot of potential in state reporting.
Yes, as do I. I'm very much in favour of the qualitative, text-based, voluntary state reports on international humanitarian law implementation. I'm very much less in favour, and I think from what you've said, you would agree with me on this. I'm less in favour of a tick box approach, simply to state that since the last report 4 or 5 years ago, that we have simply continued our military training in international humanitarian law. That does not encourage discursive engagement interstate within the Common Article 1 ensure respect obligation, however you construct the breadth of that as a de jure obligation. But something approaching the treaty body state reports within the UN human rights system, so not the Universal Periodic Review, but the treaty body reports, would actually, I think, be much more informative than a rigid bureaucratic template on international humanitarian law implementation and compliance. So what my colleagues and I would like to do is to co-produce with military lawyers a template that is truly generalizable and that is not biased towards well-resourced states in the global north, on what effective international humanitarian law training looks like, as to the extent to which you need to select between norms, be comprehensive in those norms, how training varies as between ranks, and how you deal. And again, this needs free text in paragraphs and not merely a tick box approach. How do you deal with those normative conflicts between, for example, force protection and the principle of humanity? And how you deal with the principle of proportionality and how that is weighed and then expressed in military training. So yes, I see more potential than pitfalls, but I see more pitfalls than potential in a simple tick box approach that asserts that the military training is done and is effective.